We are about 4 months into the Trump administration, and there have been a lot of changes that I want to tell you about. Even more important than the fact that I grew a beard. In 1965, Lyndon B. Johnson signed Executive Order 11246, which prohibited job discrimination by government contractors and subcontractors. I have to say that while there are a lot of things that the Trump administration has done which hasn't surprised me, this did surprise me. I thought this was settled law. I didn't think either political party wanted to see discrimination in federal contracting. I was wrong. A few weeks ago, the Office of Federal Contract Compliance, which is the organization that protected American workers from discrimination by federal contractors, laid off 90% of its staff. Next, the Executive Order on Restoring Equality of Opportunity and Meritocracy. Despite its grand-sounding title, this executive order prohibits the use of disparate impact analysis by the federal government. Disparate impact is where a seemingly neutral policy or practice adversely affects a protected group. Employers can't use these types of policies and practices unless they are job-related and consistent with business necessity. This legal standard was created by the Supreme Court in a 1971 case, Griggs versus Duke Power Company. The company required that an employee have a high school diploma or pass an intelligence test to be moved into a higher paying position. But at the time, white men in North Carolina were twice as likely to have a high school diploma than black men, and whites were 10 times more likely to pass the intelligence tests than blacks. The court ruled that while there was no evidence that this policy had a discriminatory intent, it did have a disparate impact on blacks seeking higher wages, and having a high school diploma or passing an IQ test was not related to the jobs for which this was required. While this executive order does not change the law established by the Supreme Court precedent, it does direct the EEOC to cease investigating and litigating disparate impact cases. A similar dynamic is happening at the EEOC in cases involving gender identity. But before I get into that, I just want to point out that the EEOC has been operating without a quorum for several months. The EEOC is overseen by 5 commissioners who are appointed to staggered terms so that the commission always has 2 Democrats, 2 Republicans, and a 5th commissioner who is the same party as the president. In a highly unusual move, President Trump fired 2 of the Democratic commissioners in January before their terms were scheduled to expire. This is unprecedented in the agency's history and has left the agency without a quorum. Officially, the EEOC cannot adopt new regulations or issue formal guidance without a quorum. However, the EEOC has removed all mentions of protection of transgender employees from their website, and staff have been directed to close cases based on gender identity without any investigation. Even so, there has been no change to the legal precedent established by the Roberts Supreme Court in Bostock versus Clayton County, which prohibits employment discrimination based on sexual orientation and gender identity. In cases where the EEOC determines that employees at federal agencies were discriminated against, the EEOC will no longer impose monetary sanctions against those agencies, including attorney's fees and costs. Major interests of the EEOC at this point appear to be anti-Christian bias and discrimination against white men. Last month, the chairwoman of the EEOC issued a commissioner's charge against Harvard University based on race, sex, and sexual orientation. The charge focused chiefly on the plight of white men and cited that over the past 10 years, the percentage of tenured professors at Harvard who are white men decreased from 64% to 56%. In the coming months, there are many more significant changes expected at the EEOC. And when they happen, I will let you know.